same. Over time, emotions climb. You felt that this was more than a fling. We both know you never get a ring. I won't apologize for keeping it real, 'cause that's how I feel. 'Cause the whole time, baby, you knew the deal. You knew the deal. I won't apologize for telling the truth. Telling the truth. See, I'ma do me, and you do you. That's what's up.
That's what's up. That's what's up. That's what's up. What's going on, everybody? How are you guys doing? This is your girl, Lady D. You saw the title, so I got a copy of the government's response to R. Kelly's motion for a new trial. I did read some of it. Instantly pissed me off. But I'm going to try my damnness not to comment and just read the damn thing to you guys, okay? Once again, I want to get a shout out to my new members. Thank you guys so much. You guys are blowing my mind, but I truly, truly appreciate it. And you will get some perks, like say what I'm about to read now. Once we get more people in our family, in our little membership, then you guys will get first dibs at that, and then we'll share with the rest of our subscribers on the channel, okay? But thank you guys so much. I know, I said I was trying to change the channel and cover different topics, and I will, and I am. It's just like I said, if anything comes through for Robert, all else stops, I'm definitely going to come on and update you guys, okay? And I meant that. So here we go. I'm going to read this to you guys. Leave your comments. It was something else I wanted to share with you today, but then I knew that they were supposed to respond today, so that superseded that. You know what I'm saying? That's okay. We ain't going nowhere. Okay. Here we go. All right. This damn government is something else. Man, there's two things I wanted to also talk to you guys about. But again, this one I know you guys been waiting on. So here we go. Government's response to defendant's motion for a new trial. This court should summarily deny Kelly's motion for a new trial. Kelly's motion is untimely under Federal Rule of Criminal Procedure Rule 33B2. There is no legal basis to support Kelly's motion under Rule 33B1 because it is not based upon newly discovered evidence. Like I said, I'm going to refrain because I want to react to that, but okay. And most glaring of all, the thrust of the motion rests upon demonstrably false factual premise. I'm sorry. Let me read that again. Damn, I messed up on that. Here we go. Let me start over. The court should summarily deny Kelly's motion for a new trial. Kelly's motion is untimely under Federal Rule of Criminal Procedure Rule 33B2. There is no legal basis to support Kelly's motion under Rule 33B1 because it is not based upon newly discovered evidence. And most glaring of all, the thrust of the motion rests upon a demonstrably false factual premise. Put succinctly, Kelly alleges a lurid conspiracy to steal his correspondence while he was in custody at the MCC on federal charges brought in the Northern District of Illinois and the Eastern District of New York. And that the government then used that stolen correspondence, to wrongfully coerce Jane to cooperate with this investigation. However, Jane agreed to cooperate with the government and testified in the grand jury before Kelly was charged or taken into custody in either case. Thus, the record establishes that the factual premise upon which Kelly's motion for a new trial rests simply could not have happened. For these reasons and the reasons set forth more fully below, Kelly's motion, docket number 498, should be denied in its entirety. Background. A. The counts of conviction. So you know how they always go over some shit you already heard, but I'm going to go and read this shit. On September 14, 2022, after a month-long jury trial, a jury convicted Kelly of count 1, 2, 3, 9, 10, 9, 10, and 12 of the superseding indictment. Docket number, these glasses, man, is messing with me. These are not good. Looks like it's 93. Docket number 93 and 334. Counts 1 through 3 charge Kelly with inducement, enticement, or coercion of Jane to engage in sexually explicit conduct for the purpose of producing a visual depiction of such conduct, video 1, video 2, and video 3, between 1998 and 99 in violation of Title 18, United States Code Section 2251A. With respect to count 1, the evidence showed that Kelly coerced Jane, who was 14 years old at the time, to engage in sex acts with Kelly while Kelly filmed the sex acts in the log cabin room inside of Kelly's home. And talking about the trial transcript, making reference 777-80. Excuse me. As depicted in video 1, Kelly handed Jane money at the start of video 1 to make it appear as if she were a prostitute instead of his, in quote, goddaughter. These mugs, something. Yeah. Oh, I'm sorry. I said I wasn't going to do that. Okay. Transcript pages 780 and 81. As further depicted in video 1, among other things, Kelly had Jane perform oral sex on Kelly and urinated on Jane. Transcript 778. With respect to counts 2, the evidence showed that Kelly filmed himself engaging in sex acts with 14-year-old Jane on Kelly's living room floor. Transcript 775. As depicted in video 2, among other things, Kelly provided Jane with Cristal champagne to drink before having Jane perform oral sex on Kelly and urinated on Jane's vagina. Transcript 776. These glasses aren't good. I got to get some better glasses. Kelly specifically directed Jane to describe herself as having a 14-year-old vagina, and Jane, who was in fact 14 years old at the time, complied. And then there's a footnote. And this is the footnote. As the jury heard when the video clips were played for the jury, Kelly did not use the word vagina and instead used a different, more vulgar word. I guess, whatever. Okay, I said I wasn't. You know it's hard for me to do this, but I'm trying. With respect, okay, that was the footnote. Transcript 777. I guess that's the page number. With respect to count 3, Kelly filmed himself engaging in sex acts with 14-year-old Jane. I should have just given you guys the shit because it's hard for me to read it without reacting to some of this shit because they being so damn scandalous. But we'll talk about it. We'll talk about it. 14-year-old Jane in Kelly's bedroom on Kelly's bed. Transcript, page 773, I guess. As depicted in video 3, among other things, Kelly had Jane perform oral sex on Kelly and asked Jane to describe her breasts as 14-year-old breasts. Transcript pages 773, 74. Kelly's sexual abuse of Jane on and off of the camera in different locations and in different states, including New York and Florida from 1997 through 2001, served as the basis for Kelly's conviction on count 9 of the superseding indictment, which charged Kelly with enticing Jane to engage in unlawful sexual conduct, namely aggravated criminal sexual abuse in violation of Title 18 United States Code Section 2422B. See transcript 739 through 40. But Kelly wasn't with only abusing Jane. Kelly also abused Jane's classmate and friend, Pauline, from 1997 to 2001. And this sexual abuse served as the basis for Kelly's conviction on count 12 of the superseding indictment, which similarly charged Kelly with enticing Pauline to engage in unlawful sexual conduct, namely aggravated criminal sexual abuse in violation of Title 18 United States Code Section 2422B. E.g. TR 2288-89. Trial transcript. I guess the EG is for example or reference to some shit. I don't know. I forgot what that means. That's like saying IE, I think. Right? I don't know. Pauline met Kelly through Jane when Pauline was 14 years old. Transcript 2289. Kelly began sexually abusing Pauline when Pauline was still 14 after Pauline happened upon Kelly and Jane while Jane was naked in the log cabin room in Kelly's home. Transcript pages 2291 through 95. Kelly directed Pauline and Jane to kiss each other and fondle each other's breasts, after which Kelly groped both Pauline and Jane, transcript 2294-95. Kelly's abuse of Pauline escalated while Pauline was still 14 years old, with Kelly directing Pauline to perform oral sex on Kelly and Jane, and with Kelly progressing to having sexual intercourse with Pauline over 80 times. Transcript 2298-96-98. Kelly also sexually abused Nia. Let me drink some water on this shit because I'm trying so hard not to react to the shit. I'm choking. Please excuse me. Excuse me, y'all. Y'all know I got a lot to say. Kelly also, I'm going to start over. Kelly also sexually abused Nia. Oh, excuse me. Nia met Kelly in 1996 when she was 15 years old. Transcript 25, I guess page 2584. Nia asked Kelly for his autograph and Kelly volunteered his phone number, TR 2585. After speaking to Kelly on the phone and informing Kelly that Nia was 15 years old, Kelly arranged for Nia to fly from Atlanta to Minneapolis several weeks later to see him. Transcript 2589 through 93. While in Minneapolis, Kelly visited with Nia inside of a hotel room, at which point, among other things, Kelly invited Nia to visit Kelly to Chicago at a later date. Transcript 2598, 2602. After Nia agreed to visit Kelly in Chicago, Kelly masturbated while sitting next to Nia on the bed and kissed and touched Nia's breasts. Transcript 260103. Nia arranged to spend the summer of 96 in Chicago with family after being induced to do so by Kelly inside of the hotel room. Transcript 260405. Kelly asked Nia to visit him at his recording studio, and she did. Trial transcript 2607. Page, I don't know. I'm just going to call the shit out. Nia arrived with family members, prompting Kelly to state to Nia that Kelly thought that Nia was coming alone. Transcript 2608. Eventually, Kelly separated Nia from the group, kissing Nia and fondling, I guess that's supposed to be fondling, her breast and digitally penetrating Nia's vagina. And that's transcript 2611 through 13. This conduct served as the basis for Kelly's conviction on count 10 of the superseding indictment, which charges Kelly with enticing Nia to engage in unlawful sexual conduct, namely aggravated criminal sexual abuse in violation of Title 18, United States Code, Section 2422B. B. The sentence imposed by this court and post-conviction procedural history on February 23, 2023, the Honorable Harry D. Lynn Weber sentenced defendant to 20 years imprisonment with 1 year of the sentence on counts 1, 2, and 3 to be served consecutively to the 30-year sentence imposed upon defendant for racketeering and Mann Act violations in the United States District Court for the Eastern District of New York, docket number 426-428, United States versus Robert Kelly, court number 19 CR 286 AMD EDNY, docket 238. On April 26, 2024, the Seventh Circuit affirmed both Kelly's conviction and the sentence imposed by this court. United States versus Robert Sylvester Kelly, 99 F 4 10-8, 7th Circuit, 2024. On October 7, 2024, the Supreme Court denied Kelly's petition for a writ of certiorari. 145 Supreme Court 276. On June 11, 2025, defendant filed an emergency motion for temporary furlough from custody, along with several supplements to his motion. Docket number 485, 487, 489, 491, and 495. The government responded on June 16, 2025, docket 490. See also docket 492 and 494. The court denied defendant's motion in a written order on June 19, 2025, docket number 497. The next day, defendant filed a motion for a new trial and an emergency motion for bond, and in a separate filing, dang. I'm sorry, guys. My throat always acts up when I try to read something. I think it might be this fan I'm under. Drink some water and clear it up. I'm going to start that over. The next day, defendant filed a motion for a new trial and an emergency motion for bond, and in a separate filing, a motion to disqualify the U.S. Attorney's Office, docket 498499. On June 24, 2025, the court denied defendant's motion for bond and, among other things, directed the government to respond to the motion to disqualify the U.S. Attorney's Office by July 22, 2025, docket 501. Once the motion was fully briefed, the court denied defendant's motion to disqualify the U.S. Attorney's Office, docket 514. In the same order, the court directed the government to respond to defendant's motion for a new trial. ID. C. Kelly alleges a conspiracy to steal his jail correspondence and use it to convince Jane to cooperate, even though Jane had already cooperated before Kelly was in jail. The overwhelming majority of the allegations in Kelly's motion are made without citation to an affidavit, the record, or any form of evidence, including 100% of the allegations pertaining to Jane. Kelly alleges that after he was charged and held in custody at the MCC in Chicago, a conspiracy formed to steal his legal correspondence and private emails, docket 498 at 56-6. Kelly goes on to allege that after his communications were stolen, they were provided to an alleged informant who then arranged a meeting with Jane and Jane, New York, and Los Angeles in November 2018. There's two footnotes here. This footnote number 2. Kelly alleges that the New York prosecution was also the result of the conspiracy he alleges in his motion, and refers to a minor victim from the case in his motion as Jane N.Y. The third footnote, Kelly alleges that the meeting in Los Angeles with his stolen jail correspondence occurred in November 2018, docket 498 at 8-9. Kelly was not taken into custody until July 2019, docket number 1824. Docket 498 at 8-9. As this supposed meeting in Los Angeles in November 2018, the alleged government informant showed Jane and Jane N.Y. Kelly's stolen emails and letters. Kelly, who purports to attribute statements directly to Jane in his motion, alleges that Jane never would have cooperated against Kelly had she not seen Kelly's stolen jail correspondence. Footnote 4. Jane was represented by counsel at trial and remains represented by the same counsel. These mugs. Docket 498 at 9. Kelly characterizes Jane's exposure to Kelly's correspondence at this meeting in Los Angeles in November 2018 as Brady and Gigolo or something like that. Giglio, I'm sorry, it's pronounced Giglio. That should have been disclosed, and that Kelly only learned that this correspondence had been used to convince Jane to cooperate after the trial, making it newly discovered evidence for purposes of Rule 33. See docket 498 at 26-27. Kelly also alleges that Jane was coerced to testify because the government made Jane aware that it had evidence that her parents had conspired with Kelly to obstruct his 2008 criminal trial by accepting payments in exchange for testifying that she was not the child in video 1, and that Jane was further induced to testify with the prospect of a substantial financial reward, docket 498 at 3. Kelly alleges that these supposed revelations should have been disclosed, and that Kelly only learned that these were communicated to Jane after the trial, making it newly discovered evidence for purposes of Rule 33. See docket 498 at 26 through 27. None of Kelly's allegations can be characterized as newly discovered. To the contrary, the allegations upon which he relies are either unsupported by any evidence, objectively not true based on the public record, or plainly not new. This is that damn Junior guy. I ain't like his little ass when I was in the courtroom with his little ass. Bo, you got to come back hard on their ass. Jane was cross-examined at trial by Kelly's attorney about when she decided to cooperate. Jane testified during questioning by Kelly's attorney that she was initially uninterested in cooperating with the government, but began cooperating with the government on April 18, 2019. Trial transcript 905 through 916. Kelly's attorney was aware of this. This is footnote number 4. Jane, oh yeah, I already did that one. Okay. Lord, these damn people, when it comes to this man, Lord have mercy. Because the relevant reports were produced in discovery prior to trial, thereafter, on May 29, 2019, Jane testified in the grand jury as to the substance of the testimony she later offered at trial. See under seal Exhibit 1. Yeah, I sure tried to get those. They definitely under seal, so I couldn't get those to see exactly what he's referencing here. Jane grand jury transcript was also produced in discovery prior to the trial. According to the public docket in this case, Kelly was indicted on July 11, 2019. Lord have mercy. That just did something to me. And arrested on the same day for the charges brought in the Northern District of Illinois and the Eastern District of New York, docket 1824. Whew, that was rough. Thus, it is impossible for Kelly's jail correspondence to have been the impetuous. Sorry, guys, these damn glasses, it's just not working for me right now. Impetuous for Jane to cooperate as alleged in Kelly's motion. To the contrary, as she testified at trial, Jane cooperated well before Kelly was taken into custody. Likewise, it is not possible for Kelly's stolen jail correspondence to have been shown in a clandestine meeting in Los Angeles in November 2018 when Kelly wasn't taken into custody until July 2019. Jane also testified during cross-examination by Kelly's attorney at trial about her and her parents' potential criminal exposure and having received immunity prior to testifying. Trial transcript 917 through 18, 933 through 36. Jane was also cross-examined on the prospect of receiving restitution of Kelly if Kelly were convicted at trial, and about other benefits Jane received from the government, including Section 8 housing, a down payment, and traveled to Florida. Transcript 942-43-947-51. These damn people and this goddamn man, I can't believe these people. Seriously, this is just, whew. All right. All right. To his argument. Defendant's Rule 33 motion is based on his claim that he discovered evidence post-trial that prosecutors did not obtain, defendant's privileged legal mail and used that to influence a government witness, Jane, into changing her story. See docket 498 at 23. Sorry, guys. Let me read that part over. This 2 argument. Defendant's Rule 33 motion is based on his claim that he discovered evidence post-trial that prosecutors obtained defendant's privileged legal mail and used that to influence a government's witness, Jane, into changing her story. See docket 498-23. He claims that evidence of prosecutors meeting with Jane and other impeachment materials about Jane was not disclosed. He alleges violation of Brady/Giglow, as well as arguing that his Fifth and Sixth Amendment rights were violated. None of Kelly's arguments have merit, and his motion for a new trial should be denied. A. Legal standard. A district court may grant a new trial if, in quotes, the interest of justice so requires, end quote. Federal Rule Criminal Procedure 33A. A new trial is in the interest of justice where the, in quotes, the substantial rights of the defendant have been jeopardized by errors or omissions during trial, end quote. United States case law. I'm not reading that. Put differently, a defendant is entitled to a new trial if there is a reasonable possibility that the trial error had a prejudicial effect on the jury's verdict. Another case law. Granting a new trial in the interest of justice is reserved for only, and that's in quotes, the most extreme cases, end quotes. And courts approach such motions, quote, with great caution, end quote. Case law. That is because courts are weary of second guessing the determinations of both judge and jury. There's some more case law. BS. Damn people. A jury verdict in a criminal case is not to be overturned lightly, and therefore a Rule 33 motion is not to be granted lightly, quote unquote. A motion for a new trial based on newly discovered evidence must be filed within 3 years after the verdict. Federal Rule Criminal Procedure 33B1. Under that rule, the interest of justice requires a new trial if the additional evidence, 1, was discovered after trial, 2, could not have been discovered sooner through the exercise of due diligence, 3, is material and not merely impeaching or cumulative, and 4, probably would have led to acquittal. Case law. If not brought under Rule 33B1, then under Rule 33B2, any motion for a new trial grounded on any reason other than newly discovered evidence must be filed within 14 days after the verdict or finding of guilty, quote unquote. Federal Rule Criminal Procedure 33B2. To establish a Brady violation, defendant must demonstrate that the government suppressed evidence. The evidence was either exculpatory or impeaching, and that prejudice resulted. Case law. B. Kelly's motion is untimely. Under Rule 33b-2, any motion for a new trial grounded on any reason other than newly discovered evidence must be filed within 14 days after the verdict of finding of guilty. In this case, any motion for a new trial under Rule 33b-2 would have been due on or before, oh my God, September 28, 2022, after Kelly was found guilty on September 14, 2022. See docket 335. Notably, Kelly did file two motions for a new trial under Rule 33, one of which argued that Jane testified falsely at trial regarding her intention to seek restitution if Kelly were convicted. Docket 388, 408, both motions were denied in a written order on February 16, 2023, docket 416. Any motion for a new trial based on anything other than newly discovered evidence is now untimely. And Kelly's motion is in fact untimely because it is not based on newly discovered evidence for the reasons discussed in further detail below. C. Kelly's motion is not based on newly discovered evidence. Kelly tries to couch his these damn people something else. Kelly tries to couch his motion as one based upon newly discovered evidence to prevent it from being dismissed as untimely. But there is nothing new about Jane and her family receiving immunity or the prospect of Jane receiving restitution or benefits. Jane was cross-examined on each of these topics at trial. For example, defendant cites the fact that Jane was promised restitution as newly discovered evidence. See docket 498 at 26. The government also failed to disclose the financial promises it made to Jane. This is patently untrue. For example, defendant's attorney, and isn't it true that the U.S. Attorney's Office told you that you would be entitled to restitution if Mr. Kelly was convicted, right? Jane, yes. Defendant's attorney. Oh, Lord, nope. Any restitution is money. Wait, defense attorney. This is okay. Defense attorney. Now, this is what the defense attorney was saying. I'm going back to what I just read. And isn't it true that the U.S. Attorney's Office told you that you would be entitled to restitution if Mr. Kelly was convicted? Right? Jane, yes. Defense attorney. And restitution is money, right? Jane, yes. Defendant's attorney. And you are seeking restitution or will seek restitution if he is convicted, correct? Jane, I'm still undecided with that. No, that is not correct. Defense attorney, you haven't decided whether you're going to seek restitution? Jane, no. Defense attorney, but you know you have the right to seek restitution, correct? Jane, that is correct. Defense attorney, and the U.S. attorneys told you that you had the right to seek restitution even before you ended up giving and cooperating with them, right? Jane, that is incorrect. Trial transcript 9:14 through 15. Jane was cross-examined on this topic several more times by defense attorney. For example, defense attorneys, okay. And did you have the conversations about restitution with former ND Illinois AUSA on the phone? Jane, no, not that I can remember over the phone. Defendant's attorney, why did you speak about the restitution? Jane, the restitution was, I actually can't remember how it started out. from what I think I remember is that we were in person when that was presented to us. Defendant's attorney, okay. And she presented it to you, right? Jane, yes. Trial 94748. The cross examination on this topic continued as follows. Defendant's attorney, yes. Who told you about the restitution that you were entitled to? Jane, former ND, Illinois, USA. Defense attorney, okay. And when did that conversation take place? Jane, that was in person during one of our meetings. My lawyer was actually involved in that conversation as well. Defense attorney, okay. Anyone else? Jane, not that I can remember. I'm not sure though. Defense attorney, and how much time was spent talking about restitution? Jane, I didn't understand it, so it wasn't much time spent on it. Girl, Lord, let me stop. Okay. Jane, I didn't understand it, so it wasn't much time spent on it at all. I actually got clarity through my lawyer. Trial transcript 949. After Kelly was convicted, Kelly later filed a motion for a new trial on the basis that Jane did not testify truthfully about her intentions to seek restitution. Kelly's motion was denied. Docket 416. Thus, it is difficult to square Kelly's current allegation that the prospect of financial reward to Jane was not disclosed when Jane was questioned about it at trial, and it was the subject of Kelly's post-trial motions. And further, Kelly should be barred from even raising questions about Jane receiving restitution in a Rule 33 motion for a second time when this court already denied Kelly's previous motion for a new trial on similar grounds. Docket 48460. Boy, who the heck? Jane, okay. Jane was also cross-examined about her benefits she had received from the government, including Section 8 housing, a down payment, and travel expenses, including partial flights to and from Florida. Trial transcript 942 through 43, 949 through 51. Suffice it to say, there is nothing newly discovered about the fact that Jane received financial benefits, had contemplated seeking restitution if Kelly were convicted. Nor is there anything newly discovered about the fact that Jane and her parents faced potential criminal exposure and received immunity. Defendant's attorney, and you told the government that you would not cooperate unless they could give you an immunity deal, right? Oh, excuse me, guys. Jane, I did not tell them that. No. Defense attorney, you asked for immunity. You asked for an immunity deal through counsel, right? Jane, correct. Defendant's attorney, and you asked for immunity for parents too, right? Jane, yes. Defendant's attorney, now, if your parents didn't know anything and they were innocent in all this, why did you ask for immunity for them? Jane, because with them not being truthful the first time as far as what took place in 2008, I just wanted to make sure that they were protected with telling the truth and moving forward. Defendant's attorney, and I want to go back, and they agreed to give you immunity and protect your parents as well, right? Jane, correct. Transcript 916 through 17. Jane was later cross-examined again over 3 pages of trial transcript about having received immunity on Jane's understanding of what having received immunity meant. Trial transcript 933 through 36. Jane's mother, who testified under the pseudonym Susan, was also cross-examined at trial by Kelly's attorney about having received immunity from the government. Transcript 236 to 37, 1262 to 63. There is no basis for Kelly to now suggest, as he has, that he just discovered that Jane and Jane's parents were made aware of their potential criminal exposure for obstructing Kelly's previous Cook County criminal investigation and helping to wrongfully acquit Kelly in Kelly's 2008 criminal trial. Kelly's only remaining hope for a new trial on the basis of newly discovered evidence, quote unquote, then is the fanciful conspiracy alleging that Kelly's stolen jail correspondence was used to convince Jane to cooperate. This episode demonstrably did not happen. Footnote 5. Let's see. This is footnote 5, that a meeting with Kelly's stolen jail correspondence could not have occurred in November 2018 cannot be underscored enough. It is worth noting that Kelly's attorney cross-examined Jane at trial about, amongst other things, a series of text messages she exchanged with Kelly beginning in September of 2018. See transcript 887 through 902. The exchange continued until February 2019. Kelly clearly was not in custody. Relatedly, Kelly attorney cross-examined Jane about Jane texting Kelly about Jane and Kelly's reactions to watching the Surviving R. Kelly documentary, which did not air until January of 2019, transcript 89298. Kelly's timeline is irreconcilable with the timeline of the investigation and Jane's cooperation as set forth in the trial record, underscoring that this meeting with Kelly's jail correspondence could not have occurred. Shut your ass up. That was footnote 5. Now, where was that footnote 5 at? So I can. Where is it so I can continue? I'm sorry, guys. I don't know. That's why I hate reading them damn footnotes, because I done lost my damn spot. Oh, okay. Sorry. Okay. To the contrary, Jane cooperated with the government before Kelly was taken into custody. D. Kelly's allegations in support of his motion for a new trial are not material and would not have led to an acquittal on any counts concerning Jane. As to the topics of restitution, benefits, and immunity, Kelly's allegations are immaterial and merely impeaching and or cumulative because Jane was already cross-examined on those topics. Thus, Kelly is not entitled to a new trial on any of those bases. Case law, some more bullshit. Among other things, material and not merely impeaching or cumulative, and probably would have led to acquittal. Even if the court were to accept Kelly's allegations, which the court should not, in paren. Additionally, impeaching or cumulative evidence on topics for which Jane was already cross-examined is not material. Further, none of the evidence that Kelly claims to have newly discovered would have led to an acquittal of any count concerning Jane, counts 1, 2, 3, and 9. Kelly's motion fails to account for the offense conduct depicted in video 2, count 2, and video 3, count 3, in which Kelly and Jane explicitly discuss Jane being 14 years old. While Kelly was discussed Jane being 14 years old while Kelly was performing sex acts on her. With respect to count 1, Jane's birth certificate was admitted in evidence showing that Jane was born in 1984 and would have been a minor at the time that video 1 was filmed, as well as video 2 and 3. Them people something else. That's one damn video. These people something else. They try to act like they done cut the girl. Come on now. I'm sorry. I said I wasn't going to do that. Okay. Trial script 1176-78. All of this same conduct, in addition to the sexual abuse of Jane that occurred off camera, served as the basis to convict Kelly on count 9. And Jane's birth certificate proved that Jane was a minor at all times relevant to count 9. Further, Jane testified that she was in fact 14 years old when video 1, 2, and 3 were filmed. Additionally, cumulative cross-examination on topics that were in fact explored before the jury would not have led the jury to conclude that Jane was not a minor in the videos, particularly when her age was discussed between Kelly and her in 2 other videos. Oh my God. Objective evidence from her birth certificate proved that she was a minor in the videos and at the time of the abuse, and she testified as to her age in all of the videos. Oh my God, that damn Avenatti. Oh my God. Kelly, man, these bastards. E. Kelly's motion does not concern count 10 or count 12. Kelly's motion is totally silent as to counts 10, Nia, and 12, Pauline. While Kelly frames the government's case as resting upon the one victim and one video, docket 498 at 3-4, there were other victims, other videos, and a plethora of evidence. What? I was at this damn trial. What is? Oh my God! No, he didn't just say that. A plethora of other evidence. Judge, you should make his ass show it. Why you? Oh my God! Why you didn't attach that plethora of shit? Oh, okay. Kelly provides no basis whatever for the court to consider granting a new trial with respect to these counts of conviction. I'm sorry. Oh Lord. F. Defendant's Sixth Amendment and due process claims are not based on newly discovered evidence. Defendant claims that he is entitled to a new trial because the government allegedly embedded an informant as defendant's cellmate and tasked that individual with collecting defendant's privileged legal mail, docket 498 at 2325. First, the only evidentiary submission that touches these allegations is the declaration of defendant's alleged cellmate at the MCC, Krishan Magumudi or some shit, MOD, UG, UM, UDI. I can't pronounce that shit. I'm spell it again. MOD, UG, UMUDI, Modagum, baby, whatever. So I'm just going to say M on his ass, in which M states he took defendant's legal mail, and that M's understanding was that documents were provided to the prosecutors, quote unquote. In defendant's Chicago and New York cases, see docket 4853, paragraph 5, M also states that he, quote unquote, communicated directly with a former AUSA, id, paragraph 6. Setting aside the moment whether M is a credible witness, footnote 6, M is scheduled to be sentenced on December 11, 2015 in case number 18 CR 262 after being charged with sex trafficking and other crimes. I guess he meant to say 2025. How the hell he's scheduled to be sentenced on December 11, 2015? That's your ass get. I hope she look at this shit where with shit. All this other shit might be wrong. Okay. See docket 105355. Okay. These statements provide no support for the contention that prosecutors solicited or even received defendants' legal mail. Taking the affidavit at face value, it contains no claim of direct knowledge that any prosecutor's receipt, let alone solicitation of privileged communications. M. Conspicuously does not say, as defendant claims in his motion, that an AUSA directed him to steal defendant's legal mail or that he provided stolen legal mail to any AUSA. Second, even if defendant's allegations were true, defendant utterly fails to, utterly fails to explain how his claim constitutes newly discovered evidence or how it would have affected his trial. As noted above, a defendant seeking a new trial based on newly discovered evidence must show that the new evidence was both material and probably would have led to an acquittal. O'Malley's, some case on O'Malley ass. Okay, implicit in that framework, quote, is a requirement that the defendant must show that the new evidence would be admissible at a new trial. Case law. Defendant does not tie his constitutional claims to any admissible evidence. He does not link his constitutional claims to any evidence at all. For example, he knows, quote, the risk that the government might introduce such communications at trial, end quote, docket 498 at 25. But he does not show or even allege that the government, in fact, introduced at trial any evidence obtained in violation of defendant's Fifth and Sixth Amendment rights. Defendant's claims regarding stolen legal mail are unsupported by evidence and untrue. Likewise, defendant argues that the government used privileged information to influence, quote, witnesses in this case, end quote, and access his trial strategy. Docket number 498 at 26. Once again, defendant is unable to identify any specific trial strategy to which the government gained access and how his trial was prejudicially affected, because his claim is supported by no evidence and has no basis in fact. Defendant has not come close to meeting his burden of showing that he is entitled to a new trial under Rule 33. 3. Conclusion. Kelly's motion for a new trial is untimely by a wide margin, and Kelly has not presented evidence to support his allegations that there is newly discovered evidence warranting a new trial, as his allegations are belied by the trial record and the public docket in this case. For all the foregoing reasons, the government respectfully requests that the court deny defendant's motion for a new trial. So that's the end of that bullshit ass response from the government. Guys, leave me your comment, but I got to say mine before I end this. You see how the government, how they operate? You notice 8, 14, 14, 14, 14, 14 throughout. See, that's all that's going to grab. You know what I'm saying? So, okay, you're saying these kids, because you're 14, 15, you're a child, you're a kid, okay? So you telling me these damn kids able to get hotel rooms and shit on that, they able to travel and shit on their own? I'm puzzled by that. They hanging out all hours of the night, and these are kids? Are you serious? And females? Are you serious? Because obviously your mama cares, her ass is at the child, so you're her baby. So you mean tell me she ain't looking for your little hot ass? Something ain't adding up to me. But please know, this is just my opinion on this. It made me think about this. Where the hell for that? Yes. You flying around, you sitting up in hotel. Are you kidding me? Come on, people. And I know you damn R. Kelly haters gonna come across this damn video before I put it in members only status. You guys, this shit doesn't sound crazy to this is the whole thing. This is being, and didn't you notice how certain shit she couldn't remember? But you remember all this other shit? How is that possible? How is that possible? I don't believe it. And I was there. It wasn't all those videos, people. I'm telling you, it wasn't. It was one video that they chopped the shit up for different scenes or whatever the hell they did, but it was one. And they didn't have no damn, what was the term? What was that damn term they used about how much that plethora? Are you serious of evidence? Baby, I didn't see it. Now, Lord, man, this is such some bull. And I'm telling you, if these were actual, the way these people are saying, come on now, this is some bullshit. He stretched the shit out of that. Do you think that man is recording himself? Now you're saying she's a child, so he's old enough to know damn better. You really believe, come on now, people, if shit doesn't make sense, you gotta make sense. Stop wanting shit to be when it really isn't, just because you may have some kind of feeling on some shit. It doesn't make sense. I wish you were there. No one would have recorded no shit like that. I just don't believe, I cannot believe that. The moment I heard it, I was like, I hope that ain't they damn smoking gun. That's some bullshit. Avenatti held, he the one turned that tape over. That was one of Jennifer's biggest fucking, she kept saying it. It's not authentic. I just want to put it on the record. This is not authentic. But then people didn't care. They wanted to believe it. So this is what happens because there was no getting through. And you see how he put in quotes. See, I told y'all about that goddaughter shit. Now, I said that shit. Now, I don't know what the fuck on that one, but that kept coming back to me. This had to have some sort of fucking something to do with the decision as well, because you know. You see what I'm saying? I think that's what hurt him. And that's why that bastard wrote that the way he wrote it. Man, where is that? I'm telling you. This shit is awful, I'll tell you. This is just awful the way they did. Boy. Now that part with the goddaughter shit, I just hate it. I just hate it. And I think just because that made them believe all the other shit. For real, but that's just me. I can be wrong. But guys, please, please leave your honest opinion. You know I'm good. This is Lady D. Keep it real. Yes, that's my boy, but that goddaughter that kept. We just talked about that. We just talked about that because I've been trying to figure this shit out. You know, I really have, and that kept coming back to me. I'm like, what the? Because it just wasn't making sense. I said, could it be? Because the goddaughter said, and then I'm like, okay, godparents, what's the roles of a godparent? You know? And this was recently, we just had that. Then that bastard put that in there in quotes to judge. Look at this. Please, guys. That's the motion. Leave your comments. It's so much more I could say. I just hate it. I hate when just bullshit is clear, but people want to believe it, so they believe. The shit wasn't adding up to me. It doesn't add up. She did lie. First, I asked, just say she wasn't thinking about no damn restitution. She didn't know what that meant. Girl, please. Are you serious? That was a bunch of bullshit. And in the meantime, mind you, we were at the courthouse. We were at the sentencing. So we know about how she already had attorneys where they already had the money and shit broken down. Well, she thought her ass was going to get. Land Weber gave her ass zip. She didn't even get a penny. So you want us to believe all this? And the guy, if that happened, why didn't he give this woman restitution? It doesn't make sense to me. She was the main victim. Come on now. Something is just not adding up. Is it just me? I just don't know. But please leave your comments. I come right in the door with this. I know my husband said this woman is losing her mind, but I had told him, babe, I'm trying to do something different. He said, but I thought you weren't covering R. Kelly. I never said I wasn't covering R. Kelly. I said there's nothing really much to come to talk about. So I'm changing the way I want to do, keep it real, you know, with other topics. But anything come up about Robert, well, you know I'm coming on here. That's not going to happen. So I don't know what here. I had to make that perfectly clear. So, so some things I'll be coming on. Yes, absolutely. I'm still, because I have a couple of things I want to talk to you guys about. But this one, I just wanted to get this out of the way. Now, mind you, Bo Bridley has to reply to this. So, Bo, you have to reply to that. So all that shit that he's saying that you don't have, you didn't attach to that first motion, make sure you attach all that shit to your reply. Because you came in that, it better be strong. You came strong as hell during that press conference. So I know you're experienced, very experienced. You know how that shit goes. So you got to have a smoking gun. Prove to this little young ass, show him, okay, I didn't. Did I overlook, which none of that should have happened, but I'm just saying, in case, you know what I'm saying? Read the shit, Bo. Read every damn page, please. Don't do no rush shit. You got to December the 3rd to answer this shit. He has until December the 3rd, guys. Go through that, have your clerk, paralegal, whoever, highlight every part that he said that you didn't produce or you didn't say this and that, and attach that shit to that reply. Because I'm looking forward to that damn reply. And I sure hope you come strong. Please come strong. Help this man. Come on now, help him. Help him. Because this shit sounds terrible, doesn't it? It just sounds awful. And it just sounds so damn final. Bo, do your damn thing, man. I got some information that I know what you're capable of doing. So if you did it in that case, please help Robert. Help Robert. please. But do the shit legally. Not on. I explain where I'm coming from with you guys on that, what I'm saying, but I'm not saying. You know what I'm saying? I think I might say that for my members. And some of the perks you guys will be getting. So, guys, I'm gonna end this. Replay it because I know I was stumbling over some shit, and I'm reacting and losing my place and shit like that. So I do apologize. You know how I get. I try, but some shit just triggers me and I can't help it. Okay. Appreciate you guys for clicking on the video. Please hit the like button, share, and all that good stuff. And if you want to be a part of my membership, come on, baby. Come on and join us because your girl will be having some perks and we'll be keeping some shit real doing in membership that may not, you know. Well, I love all my subscribers, but my members, they paying for certain things and I'm going to make damn sure they get it. You know what I'm saying? So with that said, you know how I do. This is my little intro, outro, but this is my song, baby. I don't care. This is my shit. Yes, it is. Because I'm not going to apologize for keeping it real. I'm going to do me and you do you. That's all I can say on that. Chat with you guys soon. Please leave your comments. Please. I really want to know.
The real. That's what's up. Something's changed. Surprised it ain't me, but yes, that I'm to blame. All we had was this unsigned mutual agreement, but it seems like that was game. Talking fly, 'cause in your mind, way more than what you really be. So I'ma be honest and hope you do the same. Over time, emotions climb. We felt that this was more than a fling. We both know you never get a ring. I won't apologize for keeping it real, 'cause that's how I feel. 'Cause the whole time, baby, you knew the deal. You knew the deal. I won't apologize for telling the truth. Telling the truth. See, I'ma do me and you do you. That's what's up. All this pressure, 'cause not what you want me to be. But see, we ain't bound to change. Can't be cuffed. No need copping a plea. I already beat the case. Talking fly, 'cause in your mind, way more than what you really be. So I'ma be honest and hope you do the same. Over time, emotions climb. You felt that this was more than a fling. We both know you never get a ring. I won't apologize for keeping it real, 'cause that's how I feel. 'Cause the whole time, baby, you knew the deal. You knew the deal. I won't apologize for telling the truth. Telling the truth. See, I'ma do me and you do you. That's what's up. The real. That's what's up.
The real.
That's what's up.
The real.
That's what's up. The real. That's what's up.
All right, guys. You gotta get through.
That's what's up. The real.